Good afternoon, everybody, and welcome to the SOFA series webinar on stalking protection orders and knife crime prevention orders. Can I do a special shout out for Samantha Gershon, who's listening to us from Hong Kong and used to instruct me many moons ago when she worked for the Met in her former life. Funny how these very weird times should result in catching up with old friends. So before we were in this lockdown, knife crime was barely off the front pages. It's a real issue for society in general, and of course it has a very strong link to the gang problem, particularly in our major cities. The reaction of the criminal justice system has been to impose minimum terms of 6 months immediate custody for a second relevant offence. But that doesn't seem to have quelled the problem and poses real issues in respect of young offenders for whom custody is probably not the answer and who may, under the legislation, find themselves in custody earlier than they might otherwise expect to be. Obviously, it's also to be remembered that many gang members use younger siblings or younger relatives to carry knives on the basis that they are less likely to enter the criminal justice system so early. So the government answer to that is the Offensive Weapons Act 2019, which introduced knife crime prevention orders. And I'll talk about these orders at the end of this webinar and just provide you with some pointers, as they're currently being piloted by the Met and started on the 6th of April and won't go wider than the Met area until at least the middle of 2021. In 2005, Claire Bernal was a 22-year-old beauty consultant working in Harvey Nichols. She had met Michael Petch, who was the security guard at the store, and had gone on a number of dates with him. But as a result of his possessive behaviour, she decided that she didn't want to see him anymore. He could not accept that. He camped outside her flat. He hassled her with telephone calls and text messages. He was always watching her when she was working on the shop floor at Harvey Nichols and he was the security guard. She brought it to the attention of her employers, and as a result of that, he was disciplined and sacked for gross misconduct. He was arrested as he left the store. He was bailed by the magistrate's court. He pleaded guilty to a harassment offence and he was bailed again. What was not known to the police at that time was that he had managed to bring in a firearm. And on the 13th of September of 2005, he managed to gain access to the Harvey Nichols store and he shot her in the head while she was working and killed her. Claire's story is not a unique one, and it has resulted in a regressive realisation by the state that stalking should be recognised as an offence, but also that it is suitable for a legislative regime of civil preventative orders. And the Stalking Protection Act 2019 came into law on the 20th of January of this year, and Molly is going to help us with the effect of it so far as the civil orders are concerned. Molly.
Thank you, Anne. And as you say, a stalking protection order, or an SPO as it is likely to become known, is a new civil protection order which essentially aims to provide the police with an additional tool for protecting victims of stalking. Now, consultation regarding this order goes back as far as 2015-2016, and the main aim of the order is to address current gaps in what were gaps in the protective regime for victims of stalking. An SPO, if made, can contain both prohibitions and requirements which have the purpose of preventing the subject of the order, the defendant, from carrying out acts associated with stalking. Police can apply for an SPO on a freestanding application to the magistrate's court. So what that means is the defendant does not have to have a previous conviction for stalking or harassment, or indeed any previous convictions at all. And what is interesting is that the explanatory notes to the 2019 Act suggests that an SPO might be particularly useful in some cases. And examples are where, for example, the evidential threshold for a criminal prosecution has not been met, or perhaps where the victim does not support a prosecution or does not want to attend court, or indeed in cases of so-called stranger stalking. In other words, stalking involving individuals who have not been in an intimate or an intimate relationship, and where other orders such as non-molestation orders or domestic violence protection orders would not be available. And that said, it is very important to remember that an SPO can be sought in any particular instance of stalking, and it is not just for stranger stalking cases. It can be used in the domestic context as well.
And what about a breach of the order, Molly?
So a breach of an SPO is a criminal offence that is triable either way, so on summary or on indictment, with a maximum penalty of 5 years imprisonment if convicted on indictment. It is also very important to note that an SPO, once made, will require the subject of that order to notify the police of their name and address within 3 days of the order being made. And further, throughout the duration of the order, that person will have to notify the police of any change to their name or address. And the only exception to that is if the person has already been subject to notification requirements under the Sexual Offences Act 2003. And interestingly, on that notification point, the legislation does specifically provide that breach of the notification requirements is itself a criminal offence.
Thanks, Molly. And how do we apply for one?
So Section 1 of the Act specifies that the police may apply for an SPO if it appears to them that 1, the defendant has carried out acts associated with stalking, 2, the defendant poses a risk associated with stalking to another person, and 3, there is reasonable cause to believe that the proposed order is necessary to protect another person from such a risk. This is in effect a 3-limb test, and it is this same 3-limb test that will need to be set out before the magistrates, and which the magistrates will need to be satisfied of before they make an SPO.
And so can we have a look at those limbs in a bit more detail, Molly?
Yes, of course, because some of them are a little bit more complex. But if we break them down and look first at limb 1, that is that the defendant has carried out acts associated with stalking. Now, the legislation does not define the term stalking, and instead what it does is it cross-refers to Section 2A of the Protections from Harassment Act 1997, which in turn explains what acts associated with stalking actually means. And that Section 2A states that acts associated with stalking could include following a person, contacting or attempting to contact a person by any means, publishing a statement or any other material about that person or purporting to be from that person, and monitoring the use by a person of the internet or email, loitering in any place, interfering with that person's property, or watching or spying on the person. It's important to note that these various acts, that is not an exhaustive list, and there are very many acts that could constitute acts associated with stalking. So police officers should keep an open mind when engaging with the victim as to what might constitute an act associated with stalking. Limb 2, that is that the defendant poses a risk associated with stalking to another person. Now, I must admit, I find the wording of this all a little bit clunky and difficult, but it seems to me that limb 1 and limb 2 are going to be quite closely linked in any application that you make. The legislation makes clear that a risk associated with stalking can be a risk of either physical or psychological harm. And interestingly, the legislation under Section 14B makes clear that the risk that can arise from acts which the defendant knows are unwelcome to the victim, even if in other circumstances and in and of themselves those acts are not necessarily harmful. And so an example that's given in the Home Office statutory guidance that accompanies the 2019 Act is sending flowers to someone. So clearly sending flowers in and of itself is not something that usually causes harm, but in a particular circumstance, it might be known to the defendant that sending flowers to the victim is going to cause that victim psychological harm. And in that case, it could be an act that is that shows that the defendant poses a risk associated with stalking. The key point about limbs 1 and 2, as I said, and they are closely linked, is that the standard of proof to establish these two limbs is likely to be the criminal standard beyond a reasonable doubt. And many of you watching will be familiar with sexual risk orders, sexual harm prevention orders. And this is essentially quite similar to those orders in that this first limb of the test follows the House of Lords case of McCann and Crown Court at Manchester. And it is going to be the criminal standard that is required to be met before the court. It's also important to note that the 2019 Act makes clear that the acts, if you are trying to show an act that has been carried out in association with stalking, that act could have occurred inside or outside of the UK. And also it is an act that could have occurred before the 2019 Act came into force. Finally then, the third limb, and whether there was reasonable cause to believe that an SPO is necessary. Again, similar to the SROs and SHIPOs procedure, and there is no clear standard of proof required for this limb, and it is likely to be a matter of judgment or evaluation for the court. And what I would say is that practically speaking, in many cases, the more difficult part of the case is going to be establishing limb 1 and 2, i.e. satisfying the court beyond a reasonable doubt that these acts have happened and that the person poses a risk associated with stalking. And if you can convince the court of that, it will likely follow that it's going to be quite easy to convince them that an order is necessary. Now, obviously, that's not the case for all cases, but it is just something that practically often it is going to be more difficult for the first two limbs, and that should be borne in mind when approaching one of these applications.
That's really helpful, Molly, thank you. And what about the procedure? Is it similar to the sexual harm orders that we're used to?
It is, yes, Anne. So the Act actually very helpfully explicitly makes clear that an SPO is a complaint, which in turn means that Part 2 of the Magistrates' Court Act 1980 applies to SPOs, and that is the part of the 1980 Act that deals with civil applications in the Magistrates' Court. The key is that this being a civil order and the court acting in its civil capacity, the civil rules of evidence will apply, which in turn, of course, means that hearsay evidence is admissible. And again, as we've noted, it will be very similar in terms of applying for a SHIPO or an SRO, in that the solicitor will need to serve a hearsay notice 21 days before the hearing under the Magistrates' Court's hearsay evidence and civil proceeding rules and the Civil Evidence Act 1995. And anyone applying for these orders should bear all of that in mind. And finally, the last point I'd make on the procedure is that although the legislation does not specify it, the Home Office guidance makes clear that an SPO, an application for an SPO, must be authorised by an officer not below the rank of a superintendent. So that is quite important to bear in mind when starting the procedure for applying for an SPO.
So the advantage there, Molly, will be that it would be unlikely that a victim of stalking would have to attend the Magistrates' Court and give evidence. But it's equally important that her statement is as full as possible, because there is no opportunity to expand upon it once you've started the hearing.
Absolutely, and that's a key thing to bear in mind. And it's also, of course, important to bear in mind that while there is this huge benefit to not having to call the victim, and it is possible under the various procedural rules that might be challenged by a defendant's representative. Yeah. And that you might have to have a hearing specifically about the hearsay issue, and the court could, if they disagree with you, order the victim to attend. And you know, based on my experience with SROs and SHIPOs, you can usually defeat that argument based on the risk to the victim. And I think in cases of stalking, that argument is going to be even stronger again, that the risk to them is huge and requiring them to come to court.
And there's a big psychological risk too, isn't there, in these sort of cases?
Absolutely, and I think that psychological risk is one that most courts are very unlikely to try and run the risk of, requiring a victim to come. And sometimes it is just a case that if the court went against you on that point and required the victim to come, you would have to consider whether or not it is still worth going for the order. And I know that that is something a lot of police forces will kind of have to do a balancing act on. But as I say, it is usually because of the general kind of tenor behind these orders, the courts usually recognise that the reason they've been implemented in this way is precisely so that police forces can protect victims where the victim doesn't want to come to court because of the very significant psychological risks to them. And
I suppose probably a good to note that before you get into that argument, it's worth including in the original victim's statement that they do not want to attend court and why they don't, rather than having to go backwards and forwards and get further material to back that up once the defendant makes the objection.
Yes, and I definitely agree with that. And it's something that does happen quite a lot that it hasn't been said in the original statement. So you can, and then you have to have a whole process after the application is started. So if it says it originally, if you check that with the victim at the very outset and make it, you know, get their clear view on it, then you can present that to the court from the very beginning.
Yeah. Okay, so there we go. We've got the evidence in and the order is going to be made. What does that look like?
So, as I say, probably one of the most interesting parts of SPOs is that they can contain either prohibitions or positive requirements. And that is quite a significant difference from SROs or SHPOs, which again, many of you watching will be aware, can only contain negative prohibitions. And in terms of the approach taken to devising one of these orders, and the Home Office guidance makes clear that best practice is for the police to engage with the victim from the very outset, to discuss with them what they think is needed in order to keep them safe and to make them feel safe. And I would highly recommend that all police forces do try and do this and talk to the victim about what is needed. The other point that's very important in terms of devising one of these orders is to bear in mind the two key principles of necessity and proportionality. So the legislation itself makes clear that a court can only impose prohibitions or requirements that are necessary to protect a person from risk associated with stalking. And it is also a general principle, but it is expressly set out in the Home Office guidance that any order made must be proportionate, and it must be tailored to the individual facts of the case. So what you don't want is just wholesale generic orders that maybe include prohibitions or requirements that have no actual relevance to the offending that has happened. And it's also very important, and the legislation specifically states that any requirement or prohibition imposed must not, so far as practicable, impose anything that conflicts with the defendant's religious belief or interferes with the time at which they attend their workplace or an educational establishment. And you can foresee that that might cause some difficulties in some cases where, for example, the victim and the perpetrator work together or attend the same university. But it is quite an important aspect that the police force will need to keep in mind when applying for these orders, and in order to make sure that the order is proportional and interferes to the least extent possible with the defendant's private life. In terms of specific examples of prohibitions and requirements, the Home Office guidance at paragraph 61 and 62 gives a non-exhaustive list of the types of prohibitions and requirements that might be included. So it includes obvious prohibitions such as not contacting the victim by any means, not going to certain places like the victim's work address or home address, but it also includes some other potentially less obvious prohibitions that might be relevant to a particular case. So one example is you might prohibit a defendant from making vexatious applications to the family court that involve the victim. In addition, in respect of the requirements, the suggestions given in the Home Office guidance specifically say that requirements might include things like providing the police with access, requiring the person to provide the police with access to their social media accounts, their telephone, their computer, their passwords, which of course is a very useful power for the police to be able to put into an order, because it will also help with the enforceability of the order, in that the police can then check whether the person is actually continuing to engage in stalking related behaviour to the victim. But the Home Office guidance also says that requirements might include things like attending treatment programs that are available in the area, and having a mental health assessment, undergoing drugs and alcohol treatment programs. And it seems to me that this is quite an interesting area that might raise quite a few different practical issues for police forces to consider. And I wonder, Anne, if you could give any kind of advice or insight into those practical issues and how the police might deal with those.
Well, it seems to me that there's going to be quite a significant burden on the officer. And the guidance makes reference to a need to ensure that all the local organisations are contacted. So the clinical side of it for any mental health issues, educational side, the GP, the local authority. And although in a criminal context, that would come down to the probation service, probably, if it was a order made after a conviction, obviously that's not available to the police in this case. And it's going to be up to the police to make those contacts. Probably a little bit easier if it's a young person because the police would have access to the youth offenders team run by the local authority. But in respect of a person of full age, that's going to require quite careful work on behalf of an officer. One, to try and establish what is required, and two, to find the right channels to obtain it. Is there anything else that we need to consider, Molly, when we are going on to a SPO, devising an SPO?
Yes, and there's a few more things to just consider. And the first is the length of the SPO. The legislation says it can be for indefinite duration or for a fixed period of a minimum of 2 years. So it's important to bear in mind that if you're going for one of these, it is going to be for 2 years at an absolute minimum. It's also important to know that you can include different lengths for different prohibitions or requirements, so you can tailor it and in that way. It's also important to note that interim SPOs are available, very similar again to the interim SROs and SHIPOs that we see under that legislation. And the test for making an interim SPO is whether the magistrates consider it appropriate to make the order or not. And so obviously the standard for making an interim SPO is a lot lower than for making the full SPO. And what the Home Office guidance makes clear is that an interim SPO is really intended to protect the victim during the period between the application being made and the final determination of that application. And there is an expectation that an interim SPO will only be made for a limited period of time. And what's also interesting is that breach of an interim SPO carries the same potential criminal penalties as breach of a full SPO. There is, again, a right of appeal, as you would expect. It explicitly states in the legislation that that right of appeal is to the Crown Court and that it is held by both the defendant and the police, which is an interesting point to note, that the police can appeal any decision made by the magistrates in respect of the application. It's also interesting, and you've touched on this, Anne, the point about youths. So it is clear, and the Home Office guidance makes it clear, that one of these orders can be obtained against a child aged between 10 and 18 years old. Now, in making an application, this will clearly then proceed before the youth court. And it will also be important to note that if the youth has been in custody, the custody officer will have a statutory duty under Section 11 of the Children's Act to ensure that any concerns resulting from the detention of that young person are communicated to the appropriate agency. So it's basically the information sharing is going to be particularly important here, particularly if there is any concern that there is a risk to the young person or that their welfare is potentially an issue, and there will need to be some work around that. As Anne has already said, a yacht is likely to be involved if an SPO is sought against a child under the age of 18, and their assistance will likely be invaluable. And finally, I would highly recommend that if you are thinking about applying for an SPO in respect of a child, that you read the Home Office guidance and paragraph 72 to 77, which specifically deal with this, and that you also consider the no order principle, as the Home Office guidance calls it, which is that basically before you go applying for an SPO, there is consideration of whether there are alternatives for dealing with this young person's behaviour. And what ties into that, and is likely to be expected, is if you are making an application against a young person, and I would expect that you will see quite a bit more scrutiny from the court, and you should be expecting that scrutiny, because clearly it is quite an extraordinary thing to do to get one of these orders against a child. The next point I'd like to just highlight is the stage of the application. And this is quite an important point, because the Home Office guidance very helpfully makes explicitly clear that the police can apply for an SPO at any stage. So you can apply for it at the beginning of a criminal investigation, at the end of the criminal investigation if you've decided to NFA the matter. You can apply for it after the person has been convicted for a stalking or harassment related offence, or even if they have been acquitted of a stalking or harassment related offence. And practically, that's quite useful because it offers quite a lot of flexibility to the police, and the Home Office guidance suggests that an investigating officer might wish to consider applying for an SPO at the very beginning of a criminal investigation in order to protect the victim. And what I would say, though, is just from having talked to colleagues, there is the potential that you will see some resistance from the courts to this, and that the court might not quite, or magistrates might not quite understand why you can't just rely upon bail conditions. And so what I would say is go prepared, go to court prepared to have that discussion, and go with the Home Office guidance so that you can explicitly bring the magistrates court attention to the fact that you are allowed to apply for these orders, and that is kind of part of their intention, and also to go with the points as to why an SPO might be more useful. For example, you can put in positive requirements and that you might not be able to obtain with bail conditions. And then the final point I'd really like to make is that the Home Office guidance makes clear that the police forces should be aware of the potential risk that might arise once they apply for an SPO. And in other words, that there is a risk that the perpetrator's behaviour might escalate once the application process has started. And this is because of the particular psychology behind stalking related behaviour and the suggestion that once the application is started, it might be seen as a challenge to the perpetrator's control over their victim. So what is absolutely key is that the police engage with the victim from the outset, that the victim is aware that an SPO is going to be sought, and that the police have engaged with the victim about the potential protective measures that need to be put in place to protect him or her. And so that could include things like putting a flag on the PNC so that if the victim calls the police, there is an immediate response immediately sent out. And it could include discussion of whether or not to install a panic alarm in the victim's house. And it could include discussing whether or not the victim should change address for a short period and whether they should go stay with friends or family. And another related point to that is that if the person breaches the SPO, it is extremely important, an interim SPO or a full SPO, it is extremely important that the police deal with that very quickly and efficiently and robustly. Because what you don't want, quite clearly, is that the SPO and the perpetrator doesn't think it's actually going to be enforced. It doesn't really have any effect. You want that to be as robust a protective tool as possible. So it needs to be enforced by the police once it's in place. And finally, what I would just say is I think it would be very helpful if you are thinking about applying for an SPO to read Annex A of the Home Office guidance, which is titled Understanding Stalking, and talks a lot about the different types of stalking related behaviour, the psychology behind it, and is quite a useful tool to try and understand what is really a slightly unique and slightly unusual form of offending behaviour. And I would recommend that especially if you haven't had any previous dealings with stalking, that you read this part of the guidance.
Well, there are real Article 2 issues here, aren't there, in relation to the victims particularly. And in my introduction, I spoke about Claire Bernal. That was a case where I was originally instructed to act for the police in the inquest. And of course, that was 2005. And things have changed a lot since then. And I think, although I didn't ultimately do the inquest, the police took a rather back row then. I don't think that would be the same in 2020, particularly knowing what we now know about the dangers of stalking and the reasons why the government has brought in this particular piece of legislation. There is a real issue here, and it's about safety, and it's about trying to preserve life. And with that knowledge, we have to make sure that the police act on, as you've said, act on any breach very, very quickly, because this is risky behaviour. And it's risky behaviour by people who very often haven't committed criminal offences before. So they're very unpredictable, and they are unknown risk in the sense of very, very difficult to work out what the ultimate end game will be. Okay, we've had a few questions. There's a question from Lucy, which says this. I'll just read it out. Could you just ask them for their opinion? The Home Office guidance states that these orders will require superintendent authority. However, the legislation does not. Our lawyers are of equal rank to superintendent and will be making the decision whether it's appropriate to apply for the order. Molly states that superintendent authority would be required. Is this not discretionary, bearing in mind the most senior police lawyers will have equal rank? Can I just refer you, Lucy, to the guidance, paragraph 39, which says an application for an order must be authorised by an officer, not below the rank of superintendent. My view about that is that you would have to have, obviously it's only guidance and it's not in the legislation. So you would have to have a very good reason to depart from it being an officer not below the rank of superintendent. And in my view, a lawyer would not satisfy that criteria, because it doesn't say police staff not below the rank of superintendent, it specifies officer. And the other reason for that too, Lucy, would be that because this is a very hands-on police application. The police officer concerned is, at least in the early stages of these orders, going to need quite a lot of supervision, I think. And so therefore, operationally, it may be better if it is a police officer. Over time, we might be able to petition the Home Office to say it should be police staff, but I don't think at the moment that's what the guidance envisages. We've had another question, haven't we, Molly, from Sonia Bellaby from Cheshire. Do you want to deal with that?
Yes, absolutely. So the question from Sonia was essentially, what is the benefit, or why should you be seeking an SPO instead of a restraining order upon conviction or acquittal under the Protection from Harassment Act 1997, and specifically and particularly where the police force has to pay for an SPO and an additional fee to make the court application. And the answer to that, I mean, there's a few different answers. And I mean, the first is obviously, and it's kind of an obvious point, but is that if you can seek an SPO if a prosecution hasn't proceeded. So that's the first obvious benefit to an SPO. And it's also key to remember that while the fact that an SPO can include positive requirements, and Sonia has made the point that in her particular area there may not be anti-stalking prevention programs available, so what's really the benefit to the requirements? What I would say about that is to remember that the requirements can be multifold, so you can think of different requirements that might apply to the particular case, and that also it could include the very useful requirement that the person shows the police upon request and their phone or their social media account, and that this is likely to be a very useful requirement that can be imposed by any police force, regardless of what programs are or are not available in their local area. And the other point to remember is that with an SPO, you can seek an interim SPO, and that given the current backlog that we are likely to see in the criminal justice system, it's entirely possible that it will be quicker to try and get an interim SPO pending the conclusion of a criminal matter, and then get the full SPO, which is an advantage over the restraining order, which of course can only be obtained at the end of the criminal process. Further points that I would make in that regard is again, that, you know, without going into too much detail about the requirements to obtain an restraining order, it seems to me that it will possibly be easier, that the standard is actually easier to meet to get an SPO instead of a restraining order. And for all those reasons, that might be why you consider getting an SPO instead of a restraining order. But all of that said, there might be a few cases where actually, for whatever the particular factual circumstances, it makes no odds whether it's a restraining order or an SPO, and that's a factor that will need to be considered in every specific case.
Okay, we have another question from Kate Jackson, which says this: you've stated that the court may take up to 21 days to consider and grant an order. Are they able to grant an urgent interim order until a full order is considered or obtained?
Yes, so my understanding, sorry, I might have been unclear on what I've said previously. My understanding is yes, the court can grant an urgent interim order until a full order is obtained. So usually what would happen is you would make your application, you'll get your court date from the magistrate's court, you go to the magistrate's court, and it's probably the first time the defendant will be there and actually find out fully what's going on and what's been applied for. So at that stage, you seek the interim SPO pending directions and a final hearing on the SPO, and then that will ensure that it's made on the day as quickly as possible and it's in place to protect the victim.
So the time between making the application and getting your first hearing is likely to be very quick, isn't it?
Yes, I mean, I think that's probably something that depends on the court and the area in which you're working. I know some courts are a lot quicker about giving dates, but it is something that you maybe want to consider in terms of giving notice to the defendant when you do that, and how close to the hearing you do. You would be expected to give them some notice, and I believe there's some provisions about a summons being listed by the court, and so you would need to be aware that once you've made the application, they're going to be notified of it, and it might be a small gap of a few days where the SPO no SPO is in place, but they are aware of the order, and you will want to be proactively thinking about protective measures for that period in particular.
Yeah, okay. And then a question from Lucy saying, can they explain also how we can satisfy the necessity criteria if we have bail conditions with the same conditions as the SPO? Well, that's very interesting, Lucy, because if you've got bail conditions, you might not need an SPO at that minute. If you're then going to go to conviction, then what you require under your SPO effectively can be dealt with in that way. And a freestanding order might not be necessary. I think you have to just look at it and see how you go. Obviously, if you decide for whatever reason that there are going to be no criminal proceedings and the bail conditions are going to cease, then you'll want to dovetail that with an application for an SPO with, again, particular reference to your victim's safety. And the last question we've got on the chat at the moment is, can you please repeat, Rachel? Hello, Rachel. Can you please repeat in the guidance where I can find guidance regarding the application against a youth, please? I think that was paragraph 72, Molly, is that right?
72 to 77.
Okay. And then before we commence this webinar, we were asked a question by Kaylee Scaife, which was this. It was about mental health, those with mental health issues who commit stalking offences, and what are the considerations in the application procedure, including if there are capacity issues, and whether there's a need for an official solicitor, and also the types of positive requirements, i.e. submitting to health assessments or engaging in any advised treatments. Molly, capacity issues. What did you think about that?
So in respect of capacity issues, there is the potential that at the first hearing, you could obtain an interim SPO and then pending a capacity assessment on the individual. But again, that would, my understanding, the police would need to be very proactive in trying to arrange that, and you would need to be liaising with other organisations to see if it is possible. And if the person does not have capacity, it seems to me that it's very unlikely that an SPO is not necessarily going to be the best way to deal with their behaviour, because if they aren't capable of understanding the proceedings, you have to wonder whether the SPO is going to be effective or enforceable against them. So I would be saying in that scenario, you might want to consider whether there are other roads that can be looked at or alternatives to try and deal with the behaviour. If the person has capacity, but there are some concerns, I mean, practically speaking, my experience is that what usually does actually happen is that the court and everyone involved essentially makes reasonable adjustments for the person. And my experience is that the magistrates' courts are generally quite flexible about this. So it might be that you would allow the person to have a support worker sitting next to them through the hearing, so that they and that everyone goes slower throughout the hearing so that they can try and follow what's going on. You would certainly be looking to try and ensure that they are aware of their right to legal aid for these proceedings, and that they try and obtain legal representation, because that will be one of the biggest protective factors for them in the proceedings. And what I would highlight about all of that is that if on the first hearing you turn up and the person and the defendant isn't represented, it's going to be incumbent on you and important for you to raise any of these issues with the court if you think there are capacity issues, and to really emphasize to the court that maybe the court needs to think about measures that need to be put in place for ensuring this person understands, because as I'm sure many of you will be aware, the magistrates' court can be a very busy place, and unless someone really hammers home the point that actually everyone needs to pause and slow down a bit, it may just be all kind of rushed through a bit too quickly, and you really want to avoid that if you have any concerns about their capacity at all.
Yes, but those issues are very similar to the sort of issues that we deal with in other magistrates' court applications, aren't they? Reasonable adjustments for those who are in need of additional care and assistance. And as you say, taking time so that someone can have regular breaks if necessary, maybe even an intermediary. But do be aware, as Molly says, that if you've got somebody who is struggling with capacity issues, then you are going to put in an enforcement that is doomed to failure. And as we know, the courts have been critical of orders that are made that are just impossible to maintain. We do have some more questions. Kate Jackson is asking us, do we need the full support throughout for an SPO, such as a DVPO? absent victim protocols, sometimes a victim who may be at huge risk may withdraw support. Can we still proceed? Well, that's really difficult, isn't it? Because once we know that there is a risk to an individual from a known person, we have an Article 2 issue that arises. And you're going to get into the realms of reverse Osman warnings if somebody is not cooperating with you. So that's the area that you're getting into, Kate, if you've got a victim who is withdrawing cooperation. Does that stop you from getting an SPO? Probably not, because you've still got to try and protect her or him, even if they are not cooperating with you. But it does make the whole collaboration, which you need, very, very much more difficult. And we've got from Adil Zafar, in respect to the hearsay notice of 21 days, is it correct that the 21-day period may be waived and a shorter period given for an earlier urgent application? I understand the relevant provision is Rule 3.2 of the Magistrates' Court rules. Adil, yes, in an urgent situation, you can ask the court to abridge time and you can serve the statement in an earlier period. But you should be able to, in most cases, to protect the victim in the interim and allow the period to continue. So that's just maybe a way forward. So those are all the questions that we've got at the moment. Obviously, if you've got any questions, please feel free to email Georgina Connor at the conclusion of this or in the next few days, or actually at any time if these issues arise and you need some help. And Molly and I will be very happy to assist you if we can. So we're going to come on to look at briefly at knife crime prevention orders. I'm only going to spend about 10 minutes on this because it's not going to affect very many of you at the moment. Molly, do you want to deal with the background to this?
Yes, well, and I think you've addressed some of the background already, which is namely to say that, you know, these orders have only been introduced on a pilot scheme in April of this year, which is due to last 14 months. And that was actually a requirement of the legislation that introduced them, which is the Offensive Weapons Act 2019. And my understanding is that at the conclusion of the 14-month pilot period, and there will be an expectation that a report is put before Parliament before all of these provisions relating to knife crime prevention orders are implemented nationwide. And I think Anne has also very much touched on some of the more controversial aspects of these orders, and that there definitely has been quite a lot of media coverage of these orders and a lot of concern from a lot of individuals that they unduly criminalise young people, because it is quite clear that they are broadly meant to be dealing with young people in particular. But Anne, do you want to give us a bit more detail about what exactly a knife crime prevention order is and what the test is for applying for one of these orders?
I will, yes. So a knife crime prevention order can be made after conviction under sections 19 and 20 of the Act, or it can be a freestanding order under section 14. And we're going to look a little bit at the freestanding order. So a magistrate's court may make a knife crime prevention order in respect of a defendant aged 12 years and over, so very young. It's an application by a chief officer of police. The court has to be satisfied that on at least 2 occasions during the previous 2 years, the defendant had a bladed article without good reason or lawful authority in a public place, school premises, or further education premises. And the court thinks that it's necessary to make an order to protect the public from the risk of harm involving a bladed article, to protect any particular member of the public, including the defendant, or to prevent the defendant from committing an offence involving a bladed article. It can impose requirements and prohibitions along the lines that we've already considered in relation to the SPOs, which the court think is necessary to ensure protection or prevention. Now, in contrast to the SPOs that we've just looked at, we can only, in relation to knife crime protection orders, we can only look at the previous events if they took place after the provision came into force, and that's section 14(4) of the Act. But an application can be made without giving notice to the defendant. In some circumstances, the court can make an interim order, and in similar terms to the SPOs, it's an offence to breach the order. They look slightly different in this way. Under section 26 of the Act, a court that makes a knife crime prevention order may, or in some circumstances must, order the applicant and the defendant to attend one or more review hearings for the purposes of considering whether the order should be varied or discharged. Now, if you make an order that exceeds 12 months and that some of the requirements imposed exceed 12 months, there must be a review 4 weeks before the completion of the order. In other cases, it's voluntary, but it is a way of the courts and the police keeping some sort of monitoring, particularly on young people, during the course of the order. Under section 27 of the Act, the defendant can apply to vary, renew, or the applicant or the defendant can apply to vary, renew, or discharge the order, and there are rights of appeal. Now, as we've said, this is currently being piloted by the Met. It started the pilot on the 6th of April, and obviously we haven't got any real feel for its effectiveness because, as you know, knife crime has reduced dramatically during lockdown. So we're going to have to wait a little while to see what the effect of this is. But there has been real concern raised in the press because of this requirement that the order can be made for young people 12 years and over. It is, although it's meant to be preventative, any breach, of course, draws in the sting of the criminal justice system. And the criminal justice system has worked for many, many years to try and divert young people away from it rather than bring people into it. And for my part, I can really foresee a JR challenge on this to say that by criminalising 12-year-olds, 13-year-olds, 14-year-olds, you're actually in breach of the Beijing rules, you're in breach of the rights of the child. And the arguments that were raised in the JR in relation to reprimands and warnings, it was a Durham constabulary case, and there were a lot of arguments raised about whether or not that was effectively imposing criminal provisions on young people, or whether it was a diversion tactic. I can see those arguments coming back to be argued in relation to knife crime prevention orders in the very short term, because most people, well, let me put it the other way, gang members use younger members of their communities to carry knives. And so it is going to be, I think, the youngsters who are caught with them, and it's going to be the youngsters where the police consider that these sorts of orders are more appropriate than criminal proceedings. And there are going to be real concerns, I think, about where the line should be in relation to the effective criminalisation of very young, probably very young boys. Okay, so I think that covers all that we wanted to say, Molly. Is there anything that you wanted to add on knife crime prevention orders?
No, and I think you've covered everything. It's just to be aware that there's going to be a lot of controversy around them, most likely, and to be aware of that if they are in due course implemented and rolled out nationwide.
Yes, there's going to be a report laid before Parliament at the conclusion of the pilot. So it may be that they will amend it in some ways as a result of the pilot exercise. But it's really watch this space. The pilot is due to finish next May 2021. They may extend it, I suppose, because they may say, well, the first 3 months of the pilot, everyone was in lockdown. And so they haven't been able to get a very clear analysis and they haven't got sufficient data, but we'll just have to watch and wait and see. So thank you very much for attending our SOFA series on stalking prevention and knife crime. I hope it's been of assistance. And as we said earlier, please don't hesitate to contact us if you need any more help with it. And in the meantime, stay safe. And I very much look forward to seeing some of you soon. Thank you.
Thank you.